All right. All right. Well, thank you for calling us to order, Mr. Chair. And I'm going to proceed to the roll call now. Ms. Dawson?
Present.
Thank you. Mr. Geffen?
Present.
Mr. Irvin?
Present.
Ms. Kaser?
Present.
Judge Kulik?
Present.
Mr. Page?
Present.
Representative Robbins?
Present.
Mr. Sandoval? Mr. Sandoval? Ms. Sherlock? Ms. Sherlock? Mr. Tatum? Mr. Tatum? All right, Mr. Chair, 7 of the 10 members are present. The quorum is present.
Thank you so much, Mr. Vogel. And maybe our first order of business is to adopt meeting minutes. We have 2 meeting minutes to adopt. The meeting from the 18th of January and a very truncated meeting that occurred on the 1st of February of 2022. All of those meetings have been posted on the task force website, and requests for any changes, corrections, amendments of any type. Seeing and being there are no objections, we will adopt the meeting minutes of the 18th of January and February 1st of 2022. Mr. Vogel, you have a little bit of stuff to identify, so please.
Yes. Thank you, Mr. Chair. And it's actually regarding the task force website. So if you don't mind, I'm going to share my screen for a second. I'd just like to draw the members' attention to something we've added to the website. This is the homepage. The meeting tabs for the subcommittee meetings are here, for example. But here at the homepage, if we scroll down now, we have a means for enabling public comment. The members of the public can click submit your story here, and then they are taken to a web form where they can type out their story. By default, it's anonymous, but we have some language soliciting their contact information if they're interested in having us follow up potentially for testimony at a meeting or something like that. The language is pretty broad. It's intended to solicit the stories of people in general who have had experiences with the background study process. So people who've been subjects to the process, employers, et cetera. But if you see anything where the language could be improved, please just give me some feedback. And otherwise, I'm going to be advertising this at the full task force meeting on Friday, of course, but I wanted to advertise it in this space as well. And I have been at the other subcommittee meetings just because I know that a lot of the members have interpersonal networks with people who have been interested in submitting their stories. So if you do receive any questions like that, please direct those people to the task force homepage here. So thank you very much, Mr. Chair and members.
Thank you. And Mr. Vogel, do you think it would be possible to send everybody in the task force a link to that? So just forward it to their networks?
Certainly, Mr. Chair. I'll send out that email after this meeting.
Okay. And once somebody submits something, where does it go?
So it goes to a web form that the LCC technical staff have set up. And then in turn, the task force leadership, you, the subcommittee chairs, et cetera, will be able to see those comments and make of those what you will.
And just logistically, how do we see it? Maybe we can talk about this, off, but just making sure we're tracking those in real time. I think
Mr. Chair, it might be a conversation that's helpful to have offline, okay. But at present, it's the LCC staff who have access to that. But I can certainly share the text of those comments with you.
Thank you. Just because we don't have a lot of time, and then in addition, we weren't able to have a full meeting the last time we met, and I appreciate everybody's flexibility to ensure that we were able to come back. I still think that was really the right decision, and thank you again, Mr. Page, for your input in that. And so, as we move forward in this process, I think that we're trying to get to a point where we have some more concrete suggestions, maybe not things that are exactly language for the legislature to adopt, but start looking at maybe some possible ideas. With that in mind, we circulated a PowerPoint, and we're going to go over it today, and we're going to go over some of the issues. Hopefully we can have a nice discussion about where we think we're leaning on some of these bigger issues. This list was not designed to be exhaustive. It was just really a launching pad for having a discussion on some of these issues. So some of them were taken from the prior reports, some are just from our conversations. So what are some possible changes that this subcommittee might recommend? We've had discussions about juvenile records and how they're used in the Background Study Act. And some of the ideas or some of the possibilities that could be recommended include things like eliminate the use of juvenile records completely, eliminating juvenile records, but permitting the use of that extended juvenile jurisdiction, which allows the court to continue to supervise individuals to the age of 21, and for what we call certified records, or records of juveniles who are then certified as adults. So not somebody who actually went through the juvenile court system the whole time, but was actually reviewed and determined that the severity of the incident warranted a more serious analysis, look, and punishment. And then we also talked about using, and I think this was Judge Kulik's idea too, was, and correct me if I'm wrong, that what about using records as long as really they're supposed to be used up to the age of about 26, unless that individual was certified by the court as an adult. And I thought we could take about 10 minutes and maybe have some discussions about this and see where the group is. And certainly I encourage people to raise the bottom line. Other was meant to be real, that this is not, again, an exhaustive list, but a launching pad. So anybody have thoughts and about if we should be looking at juvenile records as something that should change? And if so, what do we think should that look like? Partial screen, Mr. Vogel. I'll ask for your help if any hands get raised.
I'll raise my hand.
Thank you, Judge.
Visually, the science. It sounds my earlier suggestion about not using juvenile or permitting juvenile records until age 26, and unless certified as an adult, that's supported by brain development science. So, and I think it's just the opposite though. I think until someone's 26, they are not fully formed. They don't have complete impulse control. So my concept, which I may not have communicated well, was that people should not be permanently disqualified for a long, long time for things that they commit either as children or when suffering under a childlike brain of lack of impulse control. That's kind of what I was getting at, that the fully formed adult has more culpability than a kid. And maybe the 26 is, even though it's science-based, I don't know if people are going to be able to wrap their heads around that. So I'm not wed to it. It was just one more idea.
Would you, and Judge, just so I'm clear, I mean, and we've tried to create this bright line distinction between juvenile records and adult records, and really to some degree, it doesn't really matter, 17 and a half to 18 and a half brain development. It's a little bit arbitrary. But with your suggestion, would we, like if an individual had an offense at the age 22, are we considering that as use in the disqualification laws or not? I'm just trying to create that distinction.
So my idea was we'll still keep in consideration adult offenses after age 18, but any juvenile offenses, once we know by age 26, anything they've committed 17 or younger, with the exception of those that are, permanently disqualification. I get that politically that's a must. But anything they committed 17 or younger by age 26, if they haven't recommitted, nothing is they are not disqualified. And we only look at any crimes, any convictions after age 18.
And right, so the department would look at, and I think we have a member of the department here, and certainly I would like to correct if I'm wrong. They're going to look at the whole piece, and each disqualification would be sort of assigned, the 7, 10, 15-year permanent category. So if you reoffended, you could have a permanent and a 7-year. So then after 7 years, that one would essentially come off or expire, but the permanent would still be there.
And my idea was, if you've got juvenile offenses that are not permanent disqualifiers, you are not, by the time you turn 26, anything that you do as a juvenile that's not a permanent disqualifier is going to be disregarded. Only those things that you may have committed from 18 to 26. But there are those people who committed juvenile offenses, they don't recommit by 26 and full brain development, and they haven't committed anything for 9 years, and it was all when they were juveniles. I personally would like to see nothing qualify them except for that handful of permanent disqualifiers.
Do others have thoughts on Judge Kulik's idea? Anybody? Well,
I would just, Mr. Chair, I would speak in support of that conceptually, that framework. I think that that demonstration that while their brain has been developing, that they still have not recommitted or re-offended is a pretty good test or indicator that they would be someone who might be qualified. And that, I think, would give, I'm tasked here with representing interests of public safety on behalf of the County Attorneys Association and law enforcement. And I'm in the county attorney's office, but I think the constituency that I would represent would feel more comfortable with something like that rather than eliminating all juvenile records. Or, I know that everyone would want to keep EJJ and those types of cases as something that can be and should be considered, because a lot of, and I don't know that there's going to be much dispute about that, but I do, a lot of time and resources go into those kinds of crimes. And I think because they do raise more red flags than the underlying crime otherwise might. So I would just speak in support to the extent that we will handle juvenile records differently, that we do that based on the science and brain development, as Judge Kulik has outlined.
And I think Mr. Page raises a really good issue here, is that this is very conceptual, and we're just sort of talking about the idea, I think, of integrating the science into the use of juvenile records, because my experience has been similar to judges that after a certain point, if there's no reoffense, sorry, I got a barking dog here. I don't know if you can hear it, but I like that idea as well. Certainly Mr. Page's affirmation of that as a possible idea, I think, is pretty helpful. Anybody else on just sort of that idea or juvenile records sort of in all? Because I think what we're going to do is disseminate some of this. Obviously, this is preliminary, to gauge, maybe even offline, what people's thoughts are, whether they think these are good ideas or not.
One other suggestion, since it says other, is I know that there are certain offenses that are permanent disqualifiers, but for those of you who may recall, I have one anecdotal story that is really, it's the exception, not the rule. But what I'm hoping for is that there's some way, after a big span of time, to do an individual assessment, because I had the permanent disqualifier of a crim sex, but it was the 11-year-old boy who committed crim sex while he was in foster care. So, he's raised in a hellish traumatic environment. He's in foster care. He commits crim sex against another foster child. And I saw him as a 31-year-old who had been no surprise, chronically homeless. And because of that, he was supposed to register forever as a predatory offender and in that 20-year span, he had committed nothing more serious than trespass and drug possession, because he was an addict for obvious reason, the trespass mostly because he was homeless, and a 20-year span. And no matter what he might do to get on his feet, he is forever disqualified because of something he did when he was 11. And I realize it's a very exceptional case, but even in those cases, I wonder if there's any way to appeal for some consideration for exceptional cases.
And I'm glad Ms. Dawson is weighing in, because she's on the remedies and is the head of that remedies group that is looking at the permanency issue. Ms. Dawson, I'm sure that's why your hand's raised.
It was, yeah. Well, and I had lost, I got my Zoom all of a sudden kicked me out and I had to restart my computer. But so hopefully if I'm missing something here, I'll correct me. But no, the remedies group is looking at the actual permanent disqualifier, and really specifically what crimes should there be a permanent disqualifier? Should the time periods be changed? Should even the offenses be changed? So we are definitely looking at that and looking at narrowing, and also talking about potentially adding something that even for the people who have the permanent disqualifier, should there be some other kind of that where there can be that human approach where we can still look at them individually to see what changes have been. So we are absolutely looking at that. The actual juvenile issue itself is one thing that we have not been touching, just because this group was looking at it. So while I have the floor, if I could also at least sort of say, the way I look at it is, I find the option of eliminating the juvenile records, but permitting the use of EJJ and certified records very attractive, because of the reason that for EJJ and certified, they've really had that secondary approach, and a court has already really taken that extra step. So to me seems like a very attractive and kind of middle ground. So there we go.
And Mr. Chair, Representative Robbins' hand is up.
Oh, please proceed, Representative. My apologies.
No worries at all, Mr. Chair. I'm still learning a lot about all of this. So I'm sure I will have additional thoughts as we continue through the process, but I did want to be on the record saying that I do not support the elimination of all juvenile records. And I think that would be very problematic for my colleagues as well. So I think there might be some room here, but I definitely would want to continue the use of the EJJ and the certified records. At least at this point in my understanding of the process.
And that's actually my position too. I think the EJJ is a whole different issue, because those are much more serious crimes. There has been a deep dive study into that particular child. I've been involved in several and have agreed with every single recommendation of, which kids need to have a much shorter leash. So I don't disagree with that at all. It's the non-EJJ kids. It's the offenses before age 14 that aren't permanent disqualifiers, that if you're non-EJJ and you manage to quit committing any crime by the time you're 26, if all of your juvenile crimes are non-serious, not the EJJ type or the permanent disqualifiers, I think those are the ones that we can start disregarding.
And I think this is really helpful to sort of start narrowing conceptually where we feel we can go. And I think it might be smart at this point. I think, Mr. Vogel, offline, we might circulate maybe a more kind of questionnaire to elicit a little bit more. just because we don't have that much time, but it seems like this is making some sense. And maybe we should just move on to the next slide, because we have talked about juvenile stuff a fair amount. One of the questions and one of the recommendations in 2007, 2008 was to start changing some of the timelines, specifically the periods of disqualification. And again, we've got 4 tiers, 7 years for targeted misdemeanor cases, 10 years for those that are gross misdemeanor, 15 years for felony cases, and then the group of permanent. We're not going to discuss permanent. That's firmly within the remedies subcommittee. But and again, the timeline, the clock, so to speak, begins after the completion of all obligations to the court. So if you have a misdemeanor, let's say a gross misdemeanor with a couple of years of probation, then that 10-year clock starts when they've completed probation. So it can often be 13 years or so from the date of the actual incident. And so I thought, just conceptually, we could have a discussion about what we thought about, again, maybe more about the 15, 10, and 7-year disqualification periods. Were those about the right amount of time, too heavy? And we're not talking about the crimes themselves, but really just, I think to some degree, those periods of time. Ms. Dawson.
Thank you. So in the remedies subcommittee, Mr. Vogel has been doing some research for us that really looks at comparing other states and just what they have available to them. And one thing I think that is becoming has been starting to show, and we're still trying to do a little bit more looking into it, is that Minnesota appears to be very unique in our breakdown of the 15, 10, and 7. Even just looking at one of the conversations we've been having after the presentation from Joanna Woolman was perhaps really looking at making recommendations that bring this more in line with the Adam Walsh Act, which really looks more at a permanent and a 5-year. And so we're still doing some more research on that, but to me, it at least appears, and I think we're still not quite done yet, but there seems to be some showing that we are unique, and changing that scheme makes sense.
And Ms. Dawson, when you talk about unique, is that what's unique specifically?
Well, so for example, one of them, like for example, I think it was Wisconsin. Let me just look at my notes here really quick. So for example, like Iowa has a 5-year, and then they have a prohibition list, but even with that, or a permanent list, but even with the permanent list, there's still discretion to the agency. North Dakota has a 5-year bar. South Dakota has a 5-year bar. And so we're finding, we're not seeing across the states this 15, 10, 7-year scheme.
Okay. Thank you. Ms. Kaser?
Thank you, Mr. Chair. Yeah, I think to piggyback, I certainly haven't done any of the research or heard any of that, but I've been in some informal other meetings, especially talking about for foster parents, relatives trying to get licensed. Minnesota is probably the most restrictive state in terms of the scheme that we have set up with that 15, 10, and 7 for crimes. And so I certainly would support changing the timeframes, looking at a reduction of certain crimes being disqualified for shorter periods of time. One suggestion I would put out there is, do we make a suggestion about when that disqualification period starts even? Because right now it's at that point of, they've discharged from the sentence, and do we look at that disqualification period starting from the point of conviction, possibly? Reason being, I think it's rather confusing for individuals when that time frame starts. You've already noted, like, they could be more than 10 years. It can be 13 years because of 3 years of probation. And
I thought Judge Kulik made a really good point. I think it was last week, maybe 2 weeks ago. I apologize. I'm lost on dates. That with COVID, we've delayed so many trials. We have a lot of cases that are going to go on for longer. So I think it's not something to ignore.
I've got lots of cases that are taking now 3 years to get to trial. And because of the backlog, it could be 4, and you've lost 4 years. And if it's certain behaviors that are concerning and should be, I don't understand why we don't use time of date of offense, because that's the key date. And why throw away 3-4 years just because COVID hit and we had to delay trial or settlement conference or whatever.
And I'll get to you, Mr. Page, right next. I did want to comment. One of the things that always struck me as difficult about it was in some of those cases, you really got punished if you took it to trial because you've extended that period so long. And that seemed unfair to me. Mr. Page, please.
Thank you, Mr. Chair. I worked with Ms. Woolman over the course of those 5 years on the foster care licensing bill, and testified in support of it in the Senate on behalf of the County Attorneys Association. And one of the ideas that we kind of came up with, and it's not the simplest, but I thought it was a fairly elegant solution, was that the time period for which you were disqualified depends on whether it was simply a criminal charge, and if you were never convicted, it ran from the time that the act was allegedly committed. If it was and I think this is accurate, if it was a conviction and you were not sentenced to a prison term, then it ran from the date that you were sentenced, I believe. And then if you were committed to prison, to the Commission of Corrections, then the date would begin when you were released from custody. And ideally, those should overlap with any period of rehabilitation or rehabilitative services that might be provided, and is a little more logical than the time of the offense as a blanket policy or the time of a conviction as a blanket policy. The idea should be that we're getting someone services and making sure that whatever happened isn't going to happen again. We strongly wanted the simplicity to be in the number of years, and so that everyone is very clear. It was either a 5-year bar or a permanent bar, or I should say disqualification rather than bar. And, I think one thing this committee as a whole should consider is what the data says about the recidivism for the particular level of crime. If we have data that indicates that very few people recidivate within a 3-year time period, which I think is common for a lot of the non-person crimes, then maybe it should be a 3-year or 4-year if we're holding these people out for licensure. But I'll leave my comments at that for now.
I appreciate that. And I think the current law is if there's a non-conviction and it's a preponderance of evidence, you go to the act committed date. But it is, I think, rather elegant to kind of create that disparity with the conviction versus the individual that is actually in prison. Because how it was always explained to me was, let's say you go to prison for 5 years and you don't get in trouble. Well, that's a pretty controlled environment, and so is it a proof of rehabilitation or just lack of ability? So, I think it is an interesting way to look at it. And I think, maybe one of the things we're really learning today is that this statute should be more based on science than it should be based on guesswork. I think the 7, 10, and 15 years was pretty easy because it just breaks down misdemeanor, gross misdemeanor, felony. That's there's no over. But, the other thing, and I'm violating what I said I wasn't going to do, and I'm going to move probably to even the next slide, is one of the hard things that people talk about with the felony, with the drug offenses, if you have a drug offense, it's 5th degree, I still think it's a felony. It's a 15-year disqualification. And a sales is a 15-year disqualification. So, I think people have argued. I mean, what you're doing is punishing some people with a health issue as opposed to a criminal problem. And I feel like that when I wrote 152 drug cases, I apologize. That's not, there are 152 drug cases, but that's the statute. And I just wrote it for those who don't know it. So the 152 crimes or drug cases have a 15-year disqualification. Regardless of whether or not we have 10 or 7, 10 or 15, is that what we want? I mean, and one of the things I always thought was bizarre is if you go through, I think, Mr. Page, I always called it a 152.18. If you go through that program, you can get it expunged in like a year. So you have people that go through that program and you have a year disqualification and then it's expunged, but others have 15 years or they don't know to get it expunged. I mean, I think there are these really significant problems with drug offenses because my experience is that once people are not using, they're doing a lot better. What does the group think about the use of, and I think our discussion today might be more about possession offenses than sales offenses. Mr. Page?
Thank you, Mr. Chair. Just a couple odd things in our laws that I think this committee should consider. One being that felony possession of marijuana starts at about a big Ziploc baggy amount of marijuana, and that we go from petty misdemeanor amount of possession of marijuana straight to a felony, and that has never quite made sense to me why there aren't misdemeanor and gross misdemeanor amounts built in. I would say, I am much more concerned as someone who's looking out for public safety, but someone who commits gross misdemeanor child abuse or child endangerment than I am with someone who has a Ziploc baggie full of a size of marijuana. I would also caution the group on some of these drug cases in that, and I guess this deals only more with using a conviction rather than a charge, but many drug cases are much more serious than whatever conviction comes out of it. Those are often plea deals for much lower amounts that are sold or amounts that are possessed for the more serious drugs. And so I would say the conviction is not always an indicator of how serious the crime necessarily was from the beginning. And I say that only because a lot of advocates sometimes say all drug offense, refer to drug offenses as a whole, and there's some very different ones, and they're processed through our legal system in a myriad of different ways.
Thank you, Ms. Page. Always helpful and insightful. Thank you so much. Someone else. Oh, hi, Judge. Please.
Yeah, there are many areas in the law where it's clear that there's a huge difference that's acknowledged between addiction and drug use versus drug sales. One of them is our drug treatment courts. In our drug treatment court, our participants are the addicts, not the sellers. And we will only consider someone who sells very small amounts to only support their habit. Because there is a bright line there. I know Mille Lacs Band of Ojibwe has legal services, including criminal defense services, and they will accept addicts and possession, the 5th degree C subs, and not sales. So we take that sentencing guidelines grid. Since there are all these, generally speaking, in everything except the disqualification, a drug felony is not a drug felony. They vary greatly, and that's been recognized by Sentencing Guidelines Commission and all these other agencies.
And Judge, maybe if you could, I mean, then does it surprise you that the Background Study Act doesn't make those different? I mean, it's just treats them like felonies.
That was one of the most surprising things that I have learned in serving on this task force is there's no differentiating. And it's the difference between, shoving your neighbor and shooting him. It's vastly different to have an addiction and have several because it can be minuscule amounts, just enough for your own use. But if you get busted, it's having the pipe and having the residue tested. You can get a 5th degree felony for residue, and that is so much different than the people with literally carloads of drugs and shocking amounts of fentanyl who drive up from Chicago into Mille Lacs County.
Okay. Does anybody, and I want to make sure that we're open to everybody's ideas on this. Does anybody have a thought that the current structure makes sense? And I just want to make sure we're opening this up to everyone without judgment or anything admonishment. What are some of the thoughts we could come up with? What if you had kind of that magic wand to change how these are used? What would be a good way to use them in a way that makes sense for public safety, for employers that want to hire people who have these, and for those individuals who have overcome addiction or are working to overcome addiction and are doing good in their lives?
I would say that if somebody has a 5th degree possession and they have established recovery journey where they have been in recovery solidly for whatever amount of time people think is a good safety net, maybe it's 2 years. Those are the folks that I see that are some of the strongest citizens because they've had to work so hard and address so many issues. And I would personally take my chance on them. But while someone's in active addiction, there's a lot of desperation out there. Obviously, that's a whole different thing. But I'm talking about the people who weren't selling, who had an addiction issue and are in recovery. And what that magic period of time is where people feel like it's safe enough, I don't know.
Judge, do you feel it's less than 15 years?
Oh my, yes.
Okay. And I think there's some issues too with how do you prove you're in recovery? It shifts some analysis to the department to start doing analysis of who's in recovery, who's succeeding in recovery. I know that we have people here from, maybe Dave can weigh in on this a little bit with any thoughts on, looking at the public safety side, understanding that when somebody is in active addiction, and please correct me on any words or phrases I'm spinning wrong, but when somebody's in active addiction, they might not be doing well and might not be in a safe situation. But then once they're doing better, they would be. Any thoughts on that, Dave, in your experience?
Yeah, we thank you, Chair. We look at, as a lot of treatment organizations do, a success rate as somebody who has not had a relapse in a 1-year period of time. So many organizations track that and then report those figures. So for me, if somebody is a year of active recovery and they've been through treatment and they're working on maintaining their clean life, sobriety, clean from drugs, they're much more likely to be a good employee than somebody who is still struggling with addiction. If you go into a residential treatment program, your life, just somebody mentioned earlier, being in jail, it's a controlled environment. Well, when you're in treatment, you can make a decision to leave. You can make a decision to sneak drugs in, which people do. But when you're out of your treatment program and you continue to live a sober life, you're starting to show that you're making good decisions on your own in not as controlled an environment. And if you do that for a period of a year, I would say that you're actively seeking to be a good citizen, to be a good person, to work on yourself. And if you go much longer than that without being able to get a job, those are one of the things that contributes to people's recidivism, is the sense of hopelessness that they can't work, they can't provide for their families, they can't buy a car, they can't get an apartment. And we're talking about drug offenses, and Judge, I think you laid it out really well. Someone that's in addiction, you need to view that differently than somebody who's driving a carload of drugs up here from Chicago. But there are other crimes in the 10-year and 15-year disqualification list that come about as a result of someone's addiction. Felony burglary, felony theft. Those oftentimes are crimes where someone who has an active addiction, they go into a house to steal things so that they can go out and sell it and support their habit. Once they're in a year of sobriety and they're living a clean life and they've been through treatment, they're not likely to go back and break into somebody's house.
Dave, does the science support that? And would you be able to find and share with the group some of the numbers on, the intersection of criminality and addiction?
It's something that I would certainly look at with one of our clinical people.
And maybe we could just have an email about that, and we can share it too and bring others in. But I think, I think the judge, I don't know what it is, 1 year, 5 years, 3, I don't know what that number is, but I think our goal is to find something that works for public safety, or recommend something that still accommodates public safety, knowing that the people that we're talking about are vulnerable and children. So, it's a scale. You got to figure out where it tips.
And it's interesting to me that the judges have gone through, there's been pretrial probation reports, there's been background checks on somebody who goes in front of the bench. There's been an evaluation of the circumstances of the crime, and then there's sentencing. And subsequent to that, and during that sentencing, we're putting rationale to it. We're putting, I think, contextual information to it. And when I look at 245 and how they treat the drug crimes, there's no rationale. It's just, if you have a felony, it's a 15-year disqualification. That doesn't make any sense.
And I'm just going to be devil's advocate here. And the pushback would be the rationale and the discretion comes in on the set aside. That's the case by case analysis. Whether that's true, but I think that's the pushback, is that's where you get that. We're going to start at 15. If you think you're special and you think this is addiction and not, ongoing crime, you can show treatment, you can show active recovery, active sobriety. We'll look at it.
Well, and is it an all or nothing with regard to disqualified from any licensure that DHS does anywhere? Because, perhaps there's an argument to be made that if you're only in recovery for a single year, working in assisted living situation where you're handing out medication might not be a good fit. But if it's to get licensed to be relative foster care for a family member, why not?
And the set aside component does look at where you want to work. It doesn't always look at specifically the job, because I know that if you got a job at a hospital, like in the laundry, and you got to set aside, you could actually move to other positions within the hospital. But I agree 100%, Judge, that it is different. I mean, obviously the medication part changes things. Ms. Kaser's had her hand up for a while. I certainly want to get to her. Please, Ms. Kaser.
Thank you, Mr. Chair. The only thing I was going to comment on is and I don't know if this is across all programs that DHS would be licensing and then doing background studies for, but a lot of these programs already have built-in processes, at least the ones that I'm familiar with, around drug offenses. So for example, when we're licensing someone for foster care, they have to also sign a documentation that shows that they've that they've had no offense, no issues with drug or alcohol the last 2 years. And if they have, then we have to go through a process in which we have to basically make a recommendation that we would support licensing them. And that might not be because they have any drug offenses. Maybe they've never had any criminal charges because of their drug or alcohol. But maybe they've struggled with drinking. And then we have to go through a process in which we have to vet that. And so the wondering is, are we kind of making people go through multiple hoops and all of these processes that aren't necessary by doing not only our internal processes for that program, but also then the background studies and the set aside and all of that. And so could things be simplified in a way? Could we allow those programs to do that work, have that discretion, make those recommendations, and simplify the background study process?
And when you say simplify, the thing that is blinking in my head too is time. That we create these extra steps. I mean, I can't tell you how many times somebody said, I was offered a job, I was disqualified during the process to get a set aside. They had to place the job and the job was no longer there. So I get a set aside, that one's gone, and they feel like they're chasing their tail. Thank you so much, Ms. Kaser. I think we've got about 10 minutes left. I want to get to the last slide. Mr. Vogel, this is the wrong side, isn't it? Or the last slide. There had been recommendations in the past about removing some of the disqualification offenses. And here were some of them that had been listed. And I will certainly weigh in on wrongfully obtaining public assistance. As a legal aid attorney for 10 years, I thought a lot of those, and I apologize to Mr. Page, it shouldn't have been prosecuted. They should have been overpayments. I thought they were mostly crimes of poverty. Our benefit levels in this country and our state are incredibly low. I don't know how anybody lives off $429 a month or whatever the MFIP. It just never made any sense to me. And then the other part I have with this too is, as being a former legal aid attorney, is we have benefit programs that are based on you working. They don't go on forever like AFDC. TANF funds are limited and you have to work. And one of the group of best out of poverty jobs are some of the healthcare jobs because they'll pay a livable wage without a 4-year degree. And so I found some of my clients to be wonderful, wonderful caregivers. So I'll get off the soapbox and open it up for discussions about things that people have seen in the statute that were disqualifiers that they didn't think should be. And again, the minimum for one of these is 7 years. So if you have receiving stolen property, you have a 7-year disqualification. Mr. Page, please.
Thank you, Your Honor, Mr. Chair.
I'll take it. I'd take that any day of the week.
Appointing you to the bench.
I'll take it.
Mr. Chair, I haven't practiced in our criminal division, so I'm a child protection attorney, so I have not had the opportunity to see some of the fraud charges that have been brought by our office or other offices. I do wonder if there is a possibility to differentiate based on an amount that was defrauded and because I do think there is the rare occasional fraudulent actor who, really rigs things and games the system and, enriches themselves when they really don't need the money. So to the extent that we can include those people in the disqualification group, I think it makes sense, but I agree for individuals who have just received barely over the non-livable amounts that those provide, I would agree with you.
I agree with Mr. Page. There's a big difference between someone fudging, that they still have a 17-year-old at home when really they're 18 and they left to get just a few more bucks than the person who runs a fake daycare Ponzi scheme and it's hundreds of thousands of dollars, who's willing to game any system in a real deep way. We had discussed termination of parental rights at one meeting, and there's a huge difference between involuntary termination of parental rights, and that's one end of the spectrum where it's, even folks don't even try and fight it. It's some egregious behaviors. And then we get young men who didn't even know they were the parent, and there's a paternity test and it's discovered they will voluntarily terminate parental rights to a child who they know is going to, be adopted, and they're fine with it. That's a pretty broad spectrum to have a single rule about termination of parental rights.
And I'd love for somebody to weigh in. I thought that the statute had changed from involuntary, and I thought one of them is 15 years.
And I can jump. I was actually
Thanks,
just
Lucas.
pulling that up when I saw you had the list. So I do believe an involuntary is 15. I was double checking if a because I don't believe a voluntary is, if you do it voluntarily under the very first subdivision in the termination statute, I don't believe that is a disqualification, period. So I believe it's still just involuntary termination. I will note, though, that the 15-year, that's not necessarily consistent with the case law on involuntaries when we're looking at, for example, if a person has another child, one of the prongs that the county can come back is if they have a prior involuntary. But there's a lot of case law that talks about how the court still has to look at the current circumstances. You can't just say you have an involuntary and you're done, and people can actually show they've been rehabilitated. It's been a while since I've looked at the case law, but I believe there are even some cases where it's only been a few years for an involuntary, and the Court of Appeals has said you can't terminate. So 15-year, I don't see as very consistent with our case law either.
It isn't. And when some of those involuntaries are tied with addiction, and somebody's now in recovery, it's a whole different thing. I did want to make a point about the voluntary terminations, because there's a really broad spectrum even among voluntary. We have voluntary terminations by parents who are, they know they're facing involuntary, but because they do not, when you have an involuntary termination, there is a legal presumption that you're not fit. So when you give birth again, if you do, that baby is pushed away from the hospital. To avoid that, some parents will voluntarily terminate just so that they don't have the presumption for the next child. And they still could very well have been found to have been, unfit, creating a dangerous situation, mistreatment, neglect, abuse, but they did it voluntarily. And so that's a big span too that needs an individual look. Is it the dad who just found out and he has no ties to the child, so he voluntarily terminates? Or is it the parent who is going to be involuntarily terminated anyway for really good cause, who decides they don't want that legal presumption? And they're going to lose their case anyway.
Those are really good. And what's interesting too is another thing that's always in place is the maltreatment law. So if an individual, actually was found to have committed maltreatment, there would be a separate mechanism, because that's a 7-year disqualification, which is sort of interesting. You have a termination case without a maltreatment finding could be 15 years, but a maltreatment would be 7. A little bit strange. We are almost out of time. We have about 2 minutes left. Does anybody have anything else? And I think the goal will be that we all have to do a little bit of homework here and start thinking a little bit more. I think we're getting some general themes about discretion, about science, about looking at things on a case-by-case basis before someone has to go through an extended request for a set-aside, to streamline it, because that might be what we end up doing, are coming up with concepts and then moving forward in the future with maybe some more concrete recommendations. But does anybody else have anything to say before we adjourn today?
Kind of wondering is there a possibility, and I don't know if this is there like a shared document or a word cloud or something that where we could put thoughts for our next meeting where people, I know that might have to be available or accessible. I don't know how the open meeting stuff goes, but just thinking about how do we start to narrow down and people can put their thoughts. I'm thinking about, your list of some of the offenses that we think should be removed from the DQ list. Could we start to kind of put that together and then our group can then talk through some of those ideas at our next meeting? I don't know.
Yeah, I love the idea, and I'm going to defer to Mr. Vogel a little bit on the open meeting issues with something like that. How is that something we can do, and how would we succeed at doing it?
Mr. Chair, Ms. Kaser, that's an excellent idea. It's actually come up at one of the previous subcommittee meetings, or at least a very similar idea. And the opinion I've gotten from the nonpartisan legal staff is that such a document wouldn't really be consistent with open meeting law. That the intent of the law as they read it would make that one of those deliberations that should be fully transparent to the public. So a potential workaround that it's the data subcommittee that the data subcommittee has been using is just simply I take notes if I have a conversation or email with someone, but that's obviously not very and then remind them, when it's appropriate. But that's not a very effective way of doing what you're thinking. Yeah, that may be a conversation that should be taken offline to try to figure out the logistics there. But it is there definitely is an open meeting law issue here.
And Ms. Kaser, I think we have a meeting tomorrow with the chairs of all the subcommittees. I think we'll raise this again and see if there are some workarounds in ways that we can comply with open meeting, but have a way to kind of share information so we're not each time we meet trying to read each other's minds. Okay. Does anybody else have anything else? Otherwise, I think we can adjourn, but I will certainly open it up one last time. It doesn't look like we have anything else. I want to thank everybody again for their flexibility and for their insight and time in this subcommittee. And we'll see you all soon.
See you. Bye now.
Bye, everybody.